think a couple of panelists are still joining. Let's give them a couple of minutes.
Yeah, we're just waiting for Desai. Who's ST, if I may ask? Does that look familiar?
Hi, Venkat. Good to see you, man.
Yeah, hi. Hi, Dinkar. How are you?
All good, and you?
All good.
Hi, guys. Hi, everyone.
Good evening, everyone, and welcome to the SKOCH India Law Forum and LITFest 2022, organized under the aegis of the 82nd SKOCH Summit. Today, we're joined by Sri Samir Kochar, author, reforms historian, and chairman of the SKOCH Group, and our panel of domain experts for our conference on insolvency, bankruptcy, and restructuring. The Insolvency and Bankruptcy Code of 2016 transformed the economic legislation's landscape, supporting around 3,500 insolvency professionals, 80 insolvency professional entities, 16 registered valuer organizations, 1 information utility, and over 3,900 registered valuers and multiple benches of the adjudicating authority. It is a robust ecosystem and has achieved much in the 5 years since its inception, but there is still a ways to go. Field data suggests that it can take 180 days for IBC cases to be admitted or initiated, issues of stakeholder rights, the scope of the IBC vis-a-vis all manner of distress situations, expansion of pre-packs beyond MSME borrowers, and the potential of recent reforms, plus the need for more reforms are all matters that need to be discussed. And so today our panel of experts will debate these issues. It's my pleasure to now introduce them all to you. First up, we have Mr. Suharsh Sinha, partner at AZB and Partners. He has over 11 years of experience and specializes in restructuring and insolvency and banking and finance. He represents resolution professionals, borrowers, institutional creditors, asset reconstruction companies, acquirers of distressed debt, and creditor companies on restructuring and insolvency proceedings, including interim finance, corporate insolvency, resolution processes, liquidation proceedings, takeovers, and related litigation. We have Mr. Venkataraman, Managing Director of Alvarez & Marsal. He's with restructuring and turnaround practice of the company. He brings 34 years of experience in the infrastructure industry. His primary areas of concentration are restructuring and insolvency, and most recently at A&M, he's been leading a mandate on managing liquidity, developing and implementing a resolution plan for large infrastructure conglomerates in India. We have Mr. K Honnesh, Group General Counsel of the Piramal Group. He is responsible for overseeing the legal function across the Piramal Group. He also heads the secretarial and compliance functions of the company. He joined the group in 2013 and has helped set up and organize the legal function across the group and plays a critical role in identifying, mitigating, and managing legal risk across the many group companies. We have Mr. Nilang T Desai, who's a senior partner at AZB and Partners, with over 17 years of experience and specialization in restructuring and insolvency, as well as structured finance. His practice focuses on a comprehensive range of domestic and international business reorganization and restructuring matters. Mr. Desai also represents various banks, financial institutions, multilateral and bilateral institutions, as well as Indian and offshore borrowers in connection with Indian and offshore structured loan transactions. We have Mr. Mrinal Chandran, who's the General Counsel for India Resurgence Fund. He has over 2 decades of experience in deal analysis, structuring, execution, restructuring, asset management, fundraising, and compliance. Previously, Mr. Chandran has worked at firms such as Clearwater Capital, Amarchand Mangaldas, and DSK Legal, where his areas of work included mergers and acquisitions, private equity, credit, financial services, and disputes. We're joined by Mr. Deepak Chauhan, Director and Head of Legal at the Wellspun Group. He has over 24 years of hands-on experience in diversified areas such as corporate and security laws, mercantile and banking transactions, real estate, disputes, and intellectual property laws. Having worked across varied sectors, he significantly contributes towards strategizing and structuring transactions, risk mitigation advice, and policy advocacy. And finally, we have Mr. Dinkar Venkatasubramanian, Indian partner and national leader for turnaround and restructuring services at EY. His functional expertise includes restructuring, due diligence, and transaction advisory. He has over 18 years of professional experience and has been a key member of EY's transaction advisory team in India for the last 16 years. He has also served in committees constituted by the Ministry of Corporate Affairs, Government of India, to assist the implementation of the IBC code of the IBC 2016. He's also currently a member of the Executive Committee of Insolvency. I'd like to now invite Mr. Samir Kochar to share a few words and open today's conference. Thank you, sir.
Thanks, Brinda, and namaskar to you all. I have very simple 2 asks from this panel, which I hope we will be able to send back to the government as recommendations. And the asks essentially are, how do you increase the speed of recovery and how do you maximize recovery? And I'm sure between so many brilliant lawyers, you've got it figured out. The reason why it is important is because, economy today is not in the best of places. And I've been saying this for a while. Inflation is up, unemployment is up, growth is down. Finally, RBI has agreed with me. They've heard me. And yesterday they have taken some action where, inflation targeting is back on their agenda. Having done that, they've also washed their hands of growth. So that leaves the tough job of growth to government. And I don't think that they have very many ideas on that either, except one idea that is going to work, which possibly is that you must increase all-round efficiency in the economy, because that doesn't impact anything adversely. The reason why it is also important is because gross fixed capital formation in India is not up to the mark. It's close to 30%. That cannot yield the kind of growth that India needs. The ICOR, which is incremental capital output ratio, is up to almost over 5, showing high degree of inefficiency in the economy. So, keeping all these things in mind, the speed of recovery is extremely essential, because that kind of makes available very precious resources that can then be used for fueling growth. But speed cannot be at the cost of, let's say, liquidation kind of success rate in IBC, which I believe is 4%. Recovery through resolution is 39%. I think both of these are suboptimal. I'm sure that all of you can do much better than this. A case in point is ILFS recovery, where they have managed 62% already. So what was the learning from that? It was not done under IBC, it was done under a special dispensation. So from that, what are the learnings? How and they can be brought? And by the way, they did a 62% recovery of a very, very large amount in 3.5 years. So what are the learnings from there? In light of that, does something need to change in IBC, the way it is structured? I mean, you're the best people to tell us that. So as I said, I have 2 simple asks, and I'm sure Suharsh will very ably guide this panel, and he has his own set of questions. But I am really, really curious to learn how do you speed it and how you maximize recovery. With that, over to you, Suharsh.
Thank you, sir. Thank you very much. And sincere thanks to you and the SKOCH Foundation for giving us the opportunity of speaking at the LITFest, and also for enabling me to curate such an interesting panel. I think having all the panelists are I have worked with them in some capacity in the past, and I continue to work with them. To have them together on one screen, I think is a huge honor and a real delight for me personally. So many thanks again to all the panelists for joining. So as Mr. Kocher has very eloquently put out, I think the doubt in the minds of the general public and those who are invested in the general macroeconomic condition in the country is the success of the bankruptcy code. Now, I think all of us can say without any hesitation that the bankruptcy code has been a resounding success. The recoveries that we have seen as a result of the bankruptcy process, and also as a result of the mere threat of the bankruptcy process, and the settlements that have occurred prior to a company going into insolvency, has been quite enormous. And if you speak to lenders, I think lenders also acknowledge that they have never had such an important tool in the history of independent India when it comes to restructuring or even for that matter, recovery of dues. Now, whether restructuring or recovery is the appropriate goal of bankruptcy law, I think we can leave that debate for another day. But the point remains that in a banking sector such as ours, where predominantly it is owned by public sector lenders, and ultimately where any losses to public sector lenders has to be back-ended by the public exchequer at some stage. The fact is that this is a very important tool in their hands for recovery as well as resolution. Having said that, the sheen or the enthusiasm around the bankruptcy code, especially in the past year or two, seems to have abated. And the idea of the forum that we have right now, the discussion that we intend to have, as Mr. Kocher has already mentioned, is to explore why that is happening. If there are any changes that can be made to the law, if there are any changes required in the mindset of professionals who are running the law, or in the various stakeholders who are invested in the law, then what are those few changes that can be made? This panel, I believe, as I mentioned, we've been fortunate to curate a very interesting panel. So we've got Dinkar and Venkat, who have worked very closely on the insolvency professional side or the restructuring professional side. They have done matters both in the IBC and outside of IBC. Venkat was at the forefront of the ILFS matter, as Mr. Kocher recently alluded to. Mrinal from IRF is part of a fund which has a very dynamic strategy of both debt and equity. He's explored all kinds of structures when it comes to acquisition and resolution of distressed assets. Deepak from the Wellspun Group is a large strategic company in India, also looking at several companies which are in distress. So very important to get Deepak's perspective as a bidder. I was hoping to have Sapna from Credit Suisse, but unfortunately she could not make it at the last minute, so we'll miss her presence. And I believe even Honnesh, I was hoping he would be able to join, but I believe even he was caught up at the last minute, so he could not join. And last but not the least, Nilang, who is a senior partner at AZB, very close friend and a colleague, who has immense experience in restructuring both in the UK and back in India. And he's worked very closely with our founding partner, Behram, and also on various committees that the government has constituted, not only on IBC, but also on liquidity in the distressed market, trading of corporate bonds, how reform to the asset reconstruction ARC structure, and so on. So without further ado, I think I'll go into some of the questions that the panel will delve upon. So I'll start with one question which is on everybody's mind, that there have been significant delays in pronouncement of orders by the bankruptcy courts. Now, whether those orders relate to admission of cases which are filed for bankruptcy, or for orders to approve resolution plans, which have been cleared by the COC. In both these cases, we find that there have been significant delays. Ideally, an admission case should not take more than a few hearings, less than 10 to 15 days, in my view, because the simple case of establishing whether a default has taken place or not. There is no scope for gray over there. And when it comes to approval of resolution plans also, as long as the mandatory contents of a resolution plan, which are specifically enumerated, if they have been satisfied, then there's very little ground or reason for the NCLT to take significant amount of time in approving plans. But that is theory. In practice, we see that there have been delays. So I'll open the forum. I'll request. I'm going with the names which are appearing in my on my screen. So I'll request Dinkar to share his views first, and then I'll go to Deepak.
Thanks, Suharsh. Evening, everyone. Thank you so much to Mr. Kocher and to the SKOCH group for having me on this panel. And I would say, yes, obviously the IBC has been a resounding success. It when there was immense push from the government, from the RBI to take the first 12 and then the next 28 into IBC, the whole system was, I would say, there was immense momentum and pressure to make this move. But as the data shows, as Suharsh has alluded, there have been delays over the last couple of years. While probably the biggest achievement of IBC has been to change the mindset of borrowers, I would like to say permanently, but that they could lose control of their businesses if they don't resolve things on time, and that's probably been the biggest achievement of IBC, which is immense. But over the last 2 or 3 years, there have been significant delays in admission, in cases being called for from a resolution standpoint, in terms of entertaining litigations that may not, that should not be probably entertained during the process. And I would say multiple reasons for this. One is obvious. If you look at the amount of vacancies that are available at the NCLTs, you can see as to at what point in time how much vacancy is there, how much have been filled, and how much are yet to be filled. As of today, I think there are probably still about 50% of the vacancies are yet to be filled. So that is clearly a big gap over there. Number two, I think some of these things which we took for granted, that if there are amounts due by a creditor, then there shouldn't be any questioning around this. There should be no adjudication around it. It's just a matter of verification, and it should be admitted. I think that somehow that has it is probably lack of understanding of what the role is, or maybe a more socialistic mindset in terms of allowing opportunity for everybody to be heard, and it to be taking its own time to get adjudicated. I think that really is probably causing much of these delays as far as admissions are concerned, because what we also have to realize that we are dealing with stressed assets here. And as everyone on this panel would agree, stressed assets are melting cubes of ice. I mean, the more you just leave it out there, you will lose value, and therefore somehow an understanding needs to be built, whether it's capacity building at the NCLT or support infrastructure to the NCLTs, that you can't. I mean, you need to. Delays are going to kill value. So that's on the admission side. But yeah, I mean, there has to be a price for litigations to be pursued and continued in courts. It can't be today. There are so many litigations around operational creditors, around process, around competing bidders that are coming in and kind of delaying the process. There has to be a threshold which will probably allow people to for some of these to be entertained by these courts. and not allow the process to be subverted. But it all comes back to getting the right people, to getting the right skill sets there, getting more commercial mindset in terms of the tribunals, as well as we see in some of the other geographies, and have a measure of commerciality around their thinking as we move forward from this. So I'll just pause there, Suharsh, and hand it back to you.
Thank you, Dinkar. Deepak, if you could have some of your thoughts on this. Yeah.
Yes, thank you, Suharsh, and good evening to everyone. You see, we have been very active in the IBC space for almost 18 months now, and very clearly, focusing on various proceedings. We have been, observing it. We have been participating in processes, and speaking more from our experiences coming from the NCLT in Gujarat and Delhi. Our experience has been that typically the process from admission to approval is taking anywhere around 400 days. So substantially long as compared to what is prescribed by the court for various reasons. Obviously, Venkat summarized very well some of those. And I would like to sort of delve upon the whole process from the time it is admitted till the time it is approved. And our view is that on many occasions, some of these applications which are getting moved, some of these applications, some of these issues which get raised, really whether they even need to come to NCLT, whether IBBI can play a very active role in terms of addressing those issues, whether those applications really need to be before NCLT in the first place. So, and this is something very specific that we wanted to bring up for all of us here, that whether now time has come that the board needs to be empowered to play a role more on a quasi-judicial side, rather than, just as a regulator who's more on the administrative side, or as a monitoring agency, or more of a framework agency, so to say. So, I mean, it's very important. It takes away a lot of burden. Just to give an example, really, it's a thought that whether the confirmation of the RP itself, whether what's the need for us to go back to NCLT, just as an example, if you look at it, really, it's something which the COC has taken a decision. It's a process which has to happen, but really whether it needs to go back to NCLT. So if you look at it this way, that the time has perhaps come that the regulator needs to be empowered more, and that would really help the process to move forward. Secondly, Suharsh, what our observation has been generally on, things, for example, multiple applications getting filed, multiple applications, interim applications, interlocutory applications, all throughout the process. So it's not a simple process of, admission and then going straight to approval. So much of litigation in between that we see, that really perhaps what needs to happen is that for what issues can actually, you can be before NCLT, that itself needs to be sort of, framed out, saying that, okay, for these issues, these specific issues, you could be before NCLT. What could be the size of the pleadings? I mean, we are seeing pleadings running into 800 pages for a single application. Now that's so much burden on NCLT at this moment, because firstly you are entertaining, and then all issues, and then after that the size of pleadings. So I think we need to, because it's a special code, it's very, very, very much required to control this at this moment. So two specific recommendations we feel on this is that one, IBBI should be empowered, and then issues for which one can go to NCLT itself should be limited. The pleading size of pleading should be limited. That would at least bring some sense and direction to the whole process to achieve within the time frame.
Thank you, Deepak. That's a very interesting point, because what does tend to happen is that in India, as you're all aware, everybody has the right to go to court to agitate their legal rights. But I think there's some level of discretion needs to be exercised by the judiciary as well, at a threshold level, to have a filter as to which of these rights being agitated are frivolous in nature and which of them deserve to be heard in full. Very often, judges do have the right, and I wish they exercise it more often, of dismissing things at a summary level. without having to serve the application on all sides, asking them to file replies and have a thorough hearing and so on. Because that leads to, often that's used as a dilatory tactic with malified purposes. So I take your point. I think there is scope for some judicial restraint or discipline in that regard. Sorry, I'd be amiss if I didn't take Venkat's views on this point as well, Venkat. Sorry, I'd be grateful to have your views on this point as well. And since you've also been one of the protagonists of the ILFS resolution, which Mr. Kocher was talking about, if you can also give us your 2 cents on what you think worked over there, and also weigh in on this question about delays at the NCLT.
Thanks, Harsh. So, I mean, if you were to look at the delay in admissions, and one of my experience and what we have seen have been on twofold. Number one is an application filed by an operational creditor can still be a matter of question, matter of diligence that needs to be done. But when an application is filed for a financial default by a financial creditor, the admission process should not take time. It's not very difficult to establish the veracity and authenticity of that default being established and the application being filed. One way of solving it could be, there were some thoughts initially that information utility or a third party be interested. This verification of the entire application, which then justifies or establishes the financial default. A third party could be put in place who will review this entire application in parallel from a debt covenant perspective, from a loan agreement perspective, from the payment history perspective, to establish that a default has happened. Once that single trigger point has been established, there's no reason why the bench should give an audience to anybody else in the ecosystem to raise their voice for the admission. That's number one observation that I've seen, and which is why the whole process, every other party comes and files an intervention application, they get heard. It should not be the case. It has to be a 0-1 situation when the application is being filed by a financial creditor. That's number one. Number two, in most of these situations, there is a consortium of lenders. There has to be a discipline among the consortium of lenders that they meet together, agree together, and one of the lead lenders files for it. And thereafter, the whole process of who is going to be the RP, who is going to be running the process, etc., is frozen. Here again, you have different lenders filing for applications at different points in time. And then each needs to be heard separately, brought all of them together. You're wasting time in the whole process, right? I mean, the lenders need to agree together and decide that, yes, it's time to file. There is a default established. You go ahead and file it. Agree upon who's going to be the resolution professional, so that 30 days later, you don't end up into a situation where somebody wants A, somebody wants B, and so on and so forth. So you can streamline that process. The two things which I feel will help the admission process, and in terms of the application, and in terms of the approval process of the resolution plan, I think the judiciary should look at only the process compliance, and that a window for natural justice has been provided for people to hear. Many a times we have seen that the commercials also get debated in some courts, not always, but there are some benches which has taken a view that commercial is a call of the COC and we don't want to interfere. So there have been instances, but probably that's more of a learning exercise than how to speed up that. I'll stop there, and on the ILFS thing, I'll come a little later,
Sure.
And speak about it.
Sure. So the next question I have, I'll address to Mrinal if that's all right. Mrinal, I'm addressing this to you specifically because given the diverse nature of deals that come through your desk that you look at, you would be looking at situations where you're looking to work with the existing promoter. There may be situations where you're looking to replace the management. There may be situations where you're submitting a bid as a resolution applicant in the IBC process. So, given your nature of work, you would have worked across the spectrum on all kinds of transactions. Given that, what are your views on some of the alternatives to IBC? I mean, do you think every distress situation should be resolved through IBC or deserves to be resolved through IBC? Or do you think there should be mechanisms which are equally viable outside of the IBC process?
No, so I think, so like, if you think about it, right, when you look at the IBC, just from an IBC's perspective, I've had the sort of misfortune, if I can say, of working under the earlier regimes when you had SICA and DRT and all that as a distress, working for a distress fund. And, look, I think, when you look back at those days, the IBC is clearly a way, far better model of resolving stress than any of those were. I mean, I've been to those BIFR offices on Barakamba Road, and I know what a pain it used to be to try and resolve anything there. So, we used to call it Hotel California. Once you check in there, you can never get out, kind of thing, right? So it was the way it was, and so we are in a much better place today. I think, I fundamentally, I believe that we overcommitted on what the IBC could deliver when we sort of put in these very aggressive timelines. We put in a process that is very process heavy, which is a creditor in possession process. When a creditor runs a process and runs it as a trustee, right? Now you see, similarly, if you see systems like in the US, Elizabeth Warren has actually written on the stuff where she says that, if you go into Chapter 7, it takes 4.5 years for stuff to get resolved. So bankruptcies are complex. Bankruptcy laws, processes around bankruptcy are complex anywhere in the world. And I think in some of the things that, we're still scratching the surface in terms of the issues that will come up in the next, say, 10, 15 years in bankruptcies as bankruptcies evolve. This code is very good. This code has everything that it needs today, in my view. Can it deliver in 1 year? I think they've done a lot to make sure that it can. We just put up 28, 29 benches now, which we didn't have, and I don't know how they're working just in terms of recent trends. But the fact, I remember being in the NCLT and one judge sitting in Kerala, one judge sitting in Calcutta, and then halfway through that the guy has to go somewhere else. So I've seen those days as well, and that is as recent as a year and a half back. So I think they're making those improvements, and it's going to take time, but they're making those improvements. The NCLAT they still haven't resolved, so that there is a funnel and a bottleneck there, which I think they need to sort of solve very quickly. So if you had to, if you had to, in the worst case, try and resolve. Sorry, my apologies for that. If you had to sort of, as a worst case, take something into the IBC and had to solve it, I think it is still, it can still be achieved in a 2-year horizon. But that doesn't mean that every asset needs to go there. So I think the lender community in this country has evolved and sort of is still evolving, but has a good understanding of how to do this outside. I think the things that have not worked are prescriptive remedies, CDR, I think June 7th. I think prescriptive remedies for that have not worked. And the reason that I think those prescriptive remedies are there is because we have a sort of public sector, bank-led banking sector, right, which has its own challenges in terms of its accountability, etc. Frankly, if I had a choice of how to do a deal, whether it should be in IBC or outside or through a June 7th or through a bilateral restructuring, I would always try and do it as a bilateral restructuring, because I think everything else in this country goes through layers of inefficiency. And that's the way credit markets work around the world. I don't think people go to bankruptcies as the first resort. People do it in the US because there's a fiduciary responsibility of the board. People will file in Australia because there's a fiduciary responsibility of board. If your company is insolvent and you are trading wrongfully, those kind of concepts are why people go in. But like I'm telling you, that you hear of companies going into Chapter 7 in the US, you don't hear of them coming out, because that process is quite arcane, it's quite complex. And I think we found that balance here where the IBC is not as complex. But I think we've also got enough mechanisms in place outside of doing this, of solving the stress without sort of having to go through a 2-year process.
Thank you, Mrinal. So just taking cue from what Mrinal has said, Dinkar, do you have any views on, what has been the reason why the alternatives to IBC have not seen as much success? I'm talking about the current regime, of course, not talking about the BIFR days, but the current alternatives to IBC that one can think of is probably the June 7th circular or using a scheme of arrangement. So those have also not seen that much success. What do you think the reason has been? Because you worked very actively with bankers on this issue. So what is the feedback you received from them?
Yeah, I think Suharsh, two big points there. One is obviously IBC had become the only channel for resolution over a period of time from 2017 to about 2017, about 20 or so. And everything was the whole mindset, because it gave a certain level of protection to the lenders for decision making. There was wash of the previous things. Everything was driven through IBC. And therefore, I mean, in my the metaphor that I use is that we are an 8-lane worth of traffic was being driven through a 2-lane highway, which is a superb highway, but it still has to be. It can't take 8 lanes of traffic right through. So the need is always to have a expanded toolkit for resolution, and for that expanded toolkit to work, you need a strong IBC, because the IBC can then become a deterrent for the commercial stakeholders, which is the borrower and the lender, and the potential new capital which comes in from funds like whom Mrinal represents. The three of them can sit together, commercially resolve this without them taking a legal course, which is a very strong deterrent, being IBC. So the IBC can neither be the first nor the only resort to resolve this thing. And the amount of traffic in IBC and the lack of bandwidth has driven people towards June 7th. I would say June 7th has been a mixed bag. I would not say it's been a failure. It's been and a lot of lenders since 2020, 19 and 20 and 21 have gone through that process to drive resolutions. We've worked on a number of them to drive resolutions through that process because of the delays, and because also the pandemic had reduced the perception of value. There were lack of bidders, the valuations were depressed. So lenders have genuinely taken up and worked through assets over there. The biggest challenge on the June 7th circular resolutions have been consensus, building lender consensus and getting one is the different, I mean, obviously many lenders, most of these are multi-banker consortium. And even if you have homogeneous set of lenders, driving consensus is difficult. But we have seen a number of these cases where there are multiple types of lenders apart from public sector banks and commercial banks. There are mutual funds and there are other entities, and trying to get them to agree has been a big challenge. What also happens is that these the other big challenge is, I would say, the bid-ask provision equation. There's always a difference between the bid and the ask, but typically in India there is this provision equation also which comes in, because until adequate provisions are sitting in the bank's books, a deal cannot happen, because you can't take more provisions. You can't see that you are seen to be taking more of a haircut than what your books allow. Otherwise, you'll be exposed to the 3 Cs unless it's under the IBC. So that's also a big deterrent to banks to agree on June 7th circular kind of resolutions that we have seen. But I think my last point there is that you need to keep expanding that resolution toolkit, whether it is the June 7th circular resolution or it is to bring consensus through the bad bank taking over and a one lender deciding some of these, which is probably something that you'll pick up later, or having a pre-pack regime which can bring the best of both outside court resolution and the benefits of the CIRP into one spectrum. And the more options we have on the table with a strong deterrent of an IBC, the appropriate option can be worked out by the commercial stakeholders sitting on the table, and it will work. Back to you, Suharsh.
Thank you, Dinkar. So I'll turn to my colleague Nilang, who incidentally does not have a virtual background. That's a real background, which you can see. So Nilang, would you have any insights on what's ailing the non-IBC resolution framework, be it June 7 or a scheme of arrangement, and what can be done to strengthen that?
Suharsh, can you hear me okay?
Yes, very clearly.
Okay. So I was just going to say, if I may just pick up 2 points before that on delays.
Of course, yeah.
Before I come to answer your question, because I don't think there is going to be any way out of the delays until we fill up the benches with adequate judges and or get enough time for IBC through dedicated benches. And it's something which you, Param, I have been saying for years now. I'm sure Dinkar and Venkat, etc. as well. Because really, I think it is a significant capacity issue. So that's like clearly number one. But on the flip side, I think a lot of these statistics which show us the delays in admission, the delays in resolution, also unfortunately play into situations where oftentimes banks or FCs just put in a company a filing, but then don't pursue it. Because the thinking is they will use that time between filing and admission to continue negotiation. So when the hearing comes up, they don't show up or they ask for more time, which is of course given, for the asking, which means that shows up in the statistic. But that's not a reflection of our courts or system. It's a reflection of a negotiation strategy. Equally, post-admission, you and I have seen so many cases these days where courts give almost for the asking a COC resolution, COC formation stay, right? Which means that you have a second bite of the cherry to go and see if you can negotiate and come out. And if you can, great. If you can't, it sticks along for 6 months, 8 months. I mean, we were talking to a client, last week, which has been admitted, but the COC hasn't been formed for 2 years. I mean, that's ridiculous. Where does that take our statistic? But all that's happening in the background is a negotiation. If our court said, no, negotiate outside my time, please. When you come to me, I'm going to admit you and I'm going to form a COC and I'm going to plow ahead. Then maybe the fear of the IBC will be a lot greater. Right now, a lot of people think, what if you're filed? Admission to hua nahi hai. Oh, what if it's admitted? I can stop it. I can stop the COC formation. So I have 2 further stages which need to be cut out to improve our statistics, quite frankly. And I think the last point I want to make on this is case management, right? I mean, we see so often where dates are given. 27 June is when the next hearing is going to be. Counsel come up and say, I'm so sorry, I'm my legs in Delhi, I'm my legs in Chennai, I'm my legs in Supreme Court. Give me 2 more weeks. And okay, fine, I'll give you 2 more weeks. But courts need to, at the start of the hearing, right, say, these are the dates. If your counsel don't show up, the next in line, the junior counsel can show up. Your instructing advocate can, start arguing. It's like in the UK, dates are taken seriously. I mean, I'm stealing a quote from someone else, but it's almost like Bollywood actors take their dates more seriously than our counsels these days in courts, right? But sorry, coming back to the question you did ask. I think, again, I'm going to steal a line from Dinkar, right? I think the fear is for a lot of the public sector bankers that how do I get to a position where the number at which I agree in the out of court is a safe number, right? Again, if it's a very large consortium, 25 banks, maybe it's more comfortable. But it's a smaller consortium, there's that fear factor. And therefore, if you go through the IBC where there's an independent process by an independent resolution professional, there's a court stamp. The COC has come together under a statutory process to stamp off on the pricing and the structure. It gives them a lot more comfort that no one's going to come after them, 5 years later while they're in retirement. So I think it's just that really that prevents a lot of bankers from going, I don't take the trouble. Let's just put it into IBC. But the other very obvious point, Suharsh, is that IBC crams down all debt, right? Whether you come to the table, don't come to the table, you're in India, you're in Batinder, you are in Bangkok, doesn't matter. All your debt is crammed down at one table. So you have a clean whitewash at the end of the process as opposed to a bilateral process where you need to get all the players to the table, discuss with all of them, even people who are completely out of the money. You need to sit at the negotiation table and talk to them, which you obviously don't need to do in IBC if you have the numbers.
Thank you. Thanks for that, Mrinal. So, on the question of whitewash, I think I'll just take you from there, because that's one of the main reasons why bidders come in the IBC process, because they get a clean slate. They don't have any past liabilities, especially with the case law that's been emerging and with the introduction of Section 32A of the IBC, which also exempts you from any attachment of the property of the corporate debtor by any investigative authority and so on. So that's certainly been a big reason why bidders are happier acquiring a company under IBC as opposed to under any other mechanism. But from a bidder perspective as well, I think there are still some concerns which are out there. Whether it be on in terms of timelines or in terms of how streamlined the process is. Venkat, you've advised quite a few bidders when it comes to the resolution process. So, in your view, what are the process-related roadblocks to effective insolvency resolution from a bidder's perspective?
See, I mean, beyond the protracted time delays that's happening in the plan application getting approved, that's where it hurts the bidder the most, right? And can a bidder do something about it? I don't think so. Hardly. They don't have the leverage to kind of do anything, in terms of expediting that process. So from a bidder perspective, they have probably identified an asset, whether it's be a fund, a corporate, it's to either aggregate to their business or as a part of an investment construct that they have in mind. They would have planned to deploy a certain amount of capital, and they would have plugged in the potential acquisition into their larger scheme of the business, which if it doesn't play out, after a point in time, it doesn't really make sense for them to pursue those acquisitions. See, these acquisitions as a certain value have a certain value at a certain given point of time when a company is trying to acquire that. So if that gets defeated, then obviously the bidder interest is lost. And where it reflects is in the subsequent processes. They really don't come forward to kind of show that level of interest. Their faith in the system erodes in some form or fashion. So that's a deterrent, which is probably limiting the bidding community also to look at an IBC. In the early days, they looked at it as a clean whitewashed asset, reasonable valuations, no skeletons dropping out of the cupboard. And in the course of time, the attachment, the tax issues, etc., also got resolved through suitable amendments to the code, etc. So there was a window where this could have become extremely attractive. Now many bidders are looking at, okay, it's good to have. I have some money in my pockets and I don't mind acquiring it, but I would like to take it at a throwaway price, which is actually becoming a big drag in the value recovery for creditors. So it's a very opportunistic outlook, unlike the initial interest where they were, lining up and pretty serious to kind of acquire these companies, barring a handful. Mostly are very, very, opportunistic outlook that people have, and they peg a very low value to it. So it's good to have. If I get it at this value, I'll take it. Otherwise, it's okay. It doesn't hurt me. It's not that I'm eager and I'm in right earnest. I really want to add this company to my portfolio to grow the business. Those kind of transactions, they would look outside of IBCs rather than follow this process, because admission to approval takes 9 months, 12 months, followed by people going up to the NCLAT, going up to the Supreme Court. All those escalation mechanisms are there, which is becoming a deterrent, I would say, from the bidder community.
Thank you.
That's what we have
very
sensed.
Interesting point, because I mean, so what I'm hearing is one of the things which you mentioned, which resonates with me as well, is that the fundamentals of the bid change, right? The bid is made at a certain point in time.
Yeah.
With the delays, the macroeconomic conditions change, the assumptions you had made change, the business fundamentals may change. So whether it is still viable or not itself becomes difficult. And and there's been recent jurisprudence to suggest that once you have thrown in your hat, you cannot withdraw. And they can be there's no scope for conditions precedent or any reasonable assumptions. So that's making it even more difficult for bidders to come into the picture. Deepak, would you like to share your views on this, given that you are actively in the market and you're evaluating assets under IBC?
Yes, Suharsh, we have been very active in this space, and I would like to come up with some very, very specific issues that we are facing. So generally what we've found is that resolution professionals are very accommodative and understand issues. So that's a general, our impression, that they understand issues. But just that the process is such that sometimes these are all challenges which we face in any case. So if you look at the whole process, the time period which is available for the actual bidding from the time RFRP is issued to the time you need to submit a resolution plan is very less in the whole chain of all activities that you're doing. Okay, from the time the data room is set up. So that time period is really very limited if you consider any bid for any acquisition. Look at any acquisition which is happening, any infrastructure project being bid out. If you look at any other sale of a company, you'd find that if you compare that to the time frame which is available in this whole process, is very short. Okay. And then you find that there are short bursts of time which are given, 10 days, 15 days, which really, sometimes don't help. This 7-day, 10-day extension really are of not great help when you're looking at an asset. So really the time frame for that period needs to be decent and should be substantial for the purposes of submitting a good bid. Data room access can be provided early, and on data room access, the quality of data, many times we are finding, certain acquisitions, certain, deals, we are finding that the data room is very well provided, that the data is available, substantial data, good, robust data. But otherwise, our impression is that the quality of data is especially when you look at stocks, inventory, ownership, title issues, intellectual property related issues, the data is insufficient. And these are very vital, because this really, you have no IBC protection on this. So the challenge that you face is that you got to do diligence. Let's say if you're doing a acquisition which has substantial land attached to it, and immediately pursuant to the acquisition, pursuant to the approval, you would end up financing on that. So you need to complete your title search. You need to do a lot of activities before you reach a stage of stability to say that, look, this is a good bid. So really, that's a challenge. The whole data, the quality of data needs to be there. And I believe there is a consultation paper on this, which has just come out and which talks exactly on these lines, which really is a good sign that this is being, in a way getting, looked at, very, very carefully. You rightly mentioned that, about the timelines and the validity of the resolution plan, you see. Now, listed companies like us, many of our listed companies which are bidding, and very difficult. Every resolution plan has to have a timeline. What we find is that, once you've submitted a resolution plan accepted by COC, goes to NCLT, no timeline to come out. Impossible. No board is going to approve that. So difficult to get through. And then you have all sorts of issues of litigation, which still crop up after that also. Very difficult to sustain a bid for an unlimited period of time. It doesn't happen anywhere. So this really needs to be addressed. And this is a forum which I would want to use to say that, it's a very serious issue for any resolution plan which once submitted and which is at NCLT, and then, just time is set large. Can't. It's very difficult to get board approvals on such things. And lastly, you see the whole bidding process, and once you reach a stage when bids have been, plans have been submitted, the whole negotiation bit is taking too long. Once you get there, and once the process of financial bid has started, there, we have seen it's taking just too long and too many rounds of negotiations, and I believe that is also under discussion. But it's a very serious issue because it needs to be very, very focused, and there should not be too much of change and tinkering with the process after that. That would be almost while you could do it, the RFRPs would provide for that, but really is it fair to change processes to to have very long negotiations? That also is something which needs to be controlled someday. So these 3 or 4 very specific observations which we have from the industry side that needs to be looked into.
Thank you, Deepak. So I'll Mrinal, if I may turn to you, because Deepak's perspective is from a strategic bidder. Yourself being a financial bidder, the reason I'm using these terms is because, as you're aware, in a IBC process, the process document often makes this distinction between a strategic bidder and a financial bidder. So as a financial bidder who has even more compliances or even more committees, investment committees and other external stakeholders who you're answerable to, does this make the process more difficult for you, or do you face more constraints and lesser flexibility as a financial bidder under IBC?
No, obviously it does, because there's also fund life to consider, and if you don't know how long this is going to take, which fund you allocate it to, there are allocation issues. So I think if you see, there are, over time, the number of financial bidders for assets has actually gone down because it's getting harder, and so the big assets will get resolved, and you can take some comfort that if it's a big asset, and there are exceptions to that, like Videocon, of course, which has gone on forever. But at least there was a sense that the big assets will get resolved fast. So maybe you get into the big ones and you can get there. But if you were trying to go for something that is small, I think other than Carval, I don't think of anyone who's really been able to solve it. And Carval also had its challenges. As I remember, they had lots of challenges. In fact, trying to withdraw from the bid, if I remember correctly. So it's become increasingly challenged for us to not just to be bidders ourselves, but even to support strategics when you go and bid, because how long do you keep stay on the hook when you don't know, like you're saying, all the reasons that both, I think all of you mentioned, which is that the fundamentals are changing. There are other issues internally in terms of governance for the funds. So those always are going to be constraints for us. And unless there is certainty to this process, and look at what's happening now. So, there is this whole set of Supreme Court judgments and EBICs where like you rightly pointed out, you cannot go a step away as a resolution plan. But COCs in Videocon is being allowed to reconsider its decision and is actually being forced by the NCLAT. So in one place, commercial wisdom, you cannot disrupt the process. But another place where there's a plan that has been put through a process, you're sort of going to open up the whole thing again. So, I think that fundamentally there's a lack of clarity, in terms of how this process ends and when it ends. And that, again, is making it very, very difficult to go and even sort of look for assets.
Thank you. Understood. On the point of resolution plans and what is a viable resolution plan, do you think, I'll turn to Dinkar and unless, sorry, Venkat, if you had a comment, sorry, I didn't want to, okay. So Dinkar, do you think there are a lot of voices which are of the view that Section 29A needs a relook? And this always draws very adverse and very strident reactions, because on one hand, you don't want to hand the keys back to the people who ran the company to the ground, especially when those people are accused of misfeasance or wrongdoing. At the same time, should the lenders really be bothered about where the money is coming from? If somebody who is a promoter and who could potentially be barred under 29A is proposing the highest plan, then should the lenders really care? So which side of the debate are you on, and do you think there is a middle ground?
Thanks, Suharsh. Yeah, that's absolutely a moot point. I would say, as you said, why was it introduced in September 2017? It was not part of the BLRC report. Yeah. It was not part of the original code. It came in later for exactly the reason, to prevent tainted people from bidding for assets and reviving them in general, not just promoters, to avoid a moral hazard that was there at that time, that promoters should not get the same assets back at steep discounts at the expense of the lenders. It served its purpose very well, because I think it went to help establish that threat in the borrower's mind that you will really lose your assets if you are flippant about it and don't resolve your problems with your lenders in time, which was great for that point in time. Where are we today? I don't have data to back this up, but I would say maybe slightly blasphemously that all of the litigations that we are talking about, which emanate in the CIRP process, are directly or indirectly linked to the promoter interest, whether it's on admission, process, or resolution plan approval, or alternate bidders. So we need to see why this is happening. That's number one. Number two is that for all of the reasons that Deepak and Mrinal mentioned, the investor group, the number of bidders have the interest except for the large assets, it's been fairly tepid because of the lack of data for diligence, because of the lack of time, and because the next level of assets, apart from the top 50 or 60, are all mid to small sized companies where unless it's like a commodity where there is no value deterioration, there aren't many bidders. who are there for these assets apart from the promoters themselves. So given that, and also I think the third angle to that is that in September 2017, the pillar of the COC was not as developed in terms of their thought process, in terms of their strength. But today, the commercial wisdom of the COC to evaluate plans and what is good and what is not, who's a fit and proper bidder, I think has evolved significantly. So given all of these things, I would say there is a very good case for re-looking at 29A, not taking it out completely, but re-looking at that, diluting it to some extent, like it has been done for the MSMEs. Obviously, you don't want willful defaulters, you don't want recalcitrant promoters to come back, but then we can probably look at the timing. The NPA plus one year plus NPAs have been exempted in case of MSMEs. We can look at that from the perspective of other CIRP cases also, and promoters could be allowed to bid. While I would say you may need to make some safeguards to ensure that their bidding is not at the expense of the lenders, and they're not shortchanged as part of this process. Obviously, there needs to be a Swiss challenge method whenever any of these bids come through. There needs to be promoters should be asked to resolve all the cases where they have defaulted rather than the specific corporate debtor that you're talking about in question. Probably you need to look at no waivers for non-compliances and offenses that have been done, like the 32A wash that comes in case of a normal bidder. Maybe that should not be extended in such cases. And also the interests of other stakeholders, like maybe listed shareholders or minority shareholders, should not be impacted through a plan which kind of disadvantages them, as it would be in the case of a normal bidder. All of these things happen. I mean, if you compare a resolution under CIRP versus where 29A is there versus June 7th circular resolution or a 12A resolution, all of these safeguards that I spoke about are there, and these give the COC or the lender group enough teeth to apply their commercial wisdom and decide whether a particular case is fit for the promoter to bid and get this asset back. So a long answer to your question, but yeah, I would say time to relook at this, time to refine this, and allow for some leeway there for faster resolutions and ensuring that these companies don't go down.
Thank you, Dinkar. Would any of the other panelists like to weigh in on this? Because this is, I think, one of the most important policy departures under IBC. I mean, as Dinkar rightly said, it wasn't part of the original scheme of IBC. And I think Venkat was part of the case which led to the rethink. I won't name that.
I was
case.
about to come to that.
But please go ahead, Venkat.
Not the first one, but a more recent one, where this interpretation of the section 29A, purely from a technical default or related to an account of the new bidder, was challenged, which has dragged on the process for 9 months in the court. So the intent was that if a company is up for under insolvency, the original promoters of this company should not get a window to sneak in at a lower value at the cost of creditors to get back that company. That was the original intent behind it, like Dinkar articulated. But it's become a technical point which is being used by the existing promoters to challenge new bidders coming in to acquire their company. And I've been part of that, one of those cases. So that technical interpretation should not be the case. The intent and the objective by which this was brought in should be retained. To that extent, I agree with Dinkar that it calls for a review in terms of trying to re-articulate what the objective and intent of this kind of a restriction on the promoters of an existing company or a corporate debtor which has gone into IBC, not being allowed to come and bid back for their own firm. As long as we limit to that, I think it shouldn't hamper the process elsewhere. And to that extent, I think it's time to revisit. Now it's purely interpreted in a very, very technical, NPA plus X months of some other account of the bidder coming and hurting them to not able to acquire this company. So that needs a revisit. I agree with Dinkar on that point.
Thank you.
So I was sentiment. So it's 29A is a real conundrum because it's not there in any other bankruptcy statute that I know of, at least, right? So we imposed this here, and I think we did it because I think Dinkar is right, and Venkat's also mentioned this, which is to sort of people not to get back doors. But in some ways, what it has done is it is penalizing business failure, which is irrespective of what the reason is. Sorry, you've lost your life's work. Now, I think obviously if that was to be the case, there would be a reaction, and that is what we're seeing in the IBC, where people are sort of reacting to their life's work. And look, you hear around the street, and all of us have heard of backdoors, and backdoors are still there, and people are trying to do stuff, and it's scary because 3-4 years on the time, we might find that these assets are going back to the people that we were trying to keep out of. But what is the objective? Why did we try to do this? That to me today is not very clear. Like, were we trying to give the initiative back to the lenders because for 2 and 3 decades the lender community was completely decimated in this country, or were we really trying to keep people out or penalize them for their failure? And I think there has to be a middle ground, which, and I think Dinkar's suggestion is very valid here, which is if they can come into the process and they can be part of that bid, and they can sort of you can still sort of facilitate the value maximization process, then I think that makes the most sense because it reduces a lot of this challenge. But the worry for me there, and it's something that Dinkar and Venkat and all will have to address, is that I think the diligence process, once that starts, once you allow these guys access, is going to be a nightmare. How do we manage that process when you want to have a fair bid process and there's a guy and you have to do management meetings, and like everything doesn't come on paper. A lot of it is just you have to glean from people. I think this process is going to become so difficult to do if you go back to sort of an environment which is not 29A. And I think that is going to be the real challenge of tinkering with 29. So we've already, through the MSME scheme, we've already brought in promoters, right? We've already, in the pre-pack for the MSMEs, we're already diluting it, not for general CRPs, but for other stuff. So that I think people are realizing that 29A is not working in some way. But I fear that it will make the process much, much more difficult. And once that happens, then it will go back to the original promoter because he's the only one who can tell you what the value is.
Deepak, do you have a view?
Yes, so Suharsh, again, speaking from the industry, and we've seen many sectors like gas-based power plants or coal allocations where businesses have failed on many occasions due to government policies. And clearly, the problem is 29AC. If you ask me, when I look at 29A, others are still okay, more get into the intent and all those things. But 29AC is so wide, the NPA bit, and you got to pay off the entire amount with all dues and charges, no restructuring allowed. So it's highly onerous. So I think if you try and look for a solution, and maybe even Nilang can come in and you can give your thoughts on this, that what's the solution? Is there a need for a general exception to say that, okay, there would be an exception to 29A based on certain parameters? Okay, so maybe that needs to come in because it's difficult to say something like 29A won't be there. It would be there in some form, but at the same time, there has to be some criteria, some exception, some basis for that exception. There is a need to give some thought to it and bring out that exception, which can be on a very case-to-case basis, where the promoters are permitted to look at the asset. And I think that will be helpful. That should be seen.
Deepak, that's a very interesting point. So 29AC, I think all of us agree that is the crux of the problem, because I think, as even Mrinal said, that you're penalizing business failure, and that's something which in a mature economy, where if you're not there already, at least where we hope to be in the near future, one needs to recognize that businesses can genuinely go down because of macroeconomic conditions. And there should be no penalty levied on a promoter or an entrepreneur for such actions. So I think from an economic perspective, from a commercial logic, I agree with all the panelists that 29A may require a revisit. But I think we should also be cognizant of the politics around it. Because how will it look if somebody who is absconding from the country, or somebody who is not convicted, because in India we know how difficult convictions are, but is on the radar of various investigative authorities for having violated several laws, is able to get back into the company at a huge haircut. Whether that is something which is politically palatable or not. So anyway, as I said, I think there is very strong commercial and business logic. The only question is, will the legislature have the appetite to change it at this juncture? For MSMEs, the risk factor was low because you don't see large defaults in MSMEs. But for assets where you have 20,000, 30,000, 40,000 crore at stake, I think the appetite of the government may be limited. But as far as 29AC is concerned, I think at least for that particular aspect, it does deserve a relook. So moving on, I have a couple of more questions. Since we have touched upon MSMEs and the exemption given to borrowers for MSME resolutions, do you think there's scope for extending the pre-pack mechanism for non-MSMEs as well and take it to larger companies? Dinkar, if you don't mind, I'll start with you again, and then I'll open up to other panelists.
Sure. I mean, you know this. I mean, I'm a big fan of the pre-pack process. I've worked on pre-packs outside of India. I think they work. I mean, the benefits, the need and the benefits of this cannot be overstated in my mind. It is meant to be swift. It is meant to be cost-effective, and avoids disruption of business by change of management and someone is taking over the market thinking the company is going down. I mean, all of those kind of negative sentiments and disruptions are avoided in the operations and management of a business. While I think how it has been adapted by the regulation in the pre-pack for the MSMEs, I also like that it gives a very high degree of control to the lenders through the process, giving them ability to step in if needed and if it doesn't go as well, which is I think a great adaptation from an Indian market perspective. And it will also enable, I think, some of the concerns that Deepak raised or Mrinal raised. It will also enable institutional investors to get all the time they want to do diligence and get access to the business while they are kind of getting a deal in place, and give them the deal visibility and certainty that they felt is missing in the CIRP process, which is a fact, that enabling them to commit the resources behind this, to go after a deal and put people behind that. It's a great, I would say it's a great marriage between CIRP, where you get where you get the legal sanction over all the plan that you want, a 32A kind of wash over these assets, while also it has the best aspects of a workout or a June 7th resolution mechanism for all the stakeholders. So I think, therefore, it's absolutely necessary for this to be expanded. I spoke earlier about expanding the whole set of resolution mechanisms, and this fits into that, is to have another alternative for this to happen and expand it to normal corporates. It will solve some of the issues of the June 7th circular in terms of building consensus that I spoke about, and allow lenders to approve in a collective way under the aegis of the law, while it will also give legal protection to them, to buyers and to the lenders alike. So clearly, for expanding this to the wider set of corporates and give another option for resolutions to happen. Just 2 points which we need to be careful of before we put this out and hope that this works. Number one, I'll come back to the point on 29A. I think like we have done it for the MSMEs, I would say relook at applicability of 29A from the perspective of pre-packs as well, because all of those benefits of greater access for diligence, information to be provided, lack of disruption and a good price discovery to happen will not happen if you don't relook at that for genuine business failure and for promoters to come back on that. So that's very important for a good pre-pack to work, in my view. And the second one, which we spoke about was the first point really, is that like the CIRP, if the courts decide to have a lot of adjudication on how this is versus just looking at the process and allowing for the lenders' commercial wisdom to determine this thing. I think if it's the latter, then it can become a big success to make sure that pre-packs are done and closed in a good, let's say, a 90-day time frame that we are speaking about, and put these assets back to normal path of growth. Yeah, but I would say with those two caveats. Back to you, Suharsh.
Thank you, Dinkar. Mrinal, Venkat, Deepak, in case you have any thoughts, any comments on extension of pre-packs to larger companies?
I agree with Dinkar again that I think that we should definitely extend it. I think once you extend it, the question is how does it, what happens to the CIRB process? Does it basically die a natural death? Because everybody will want to go down the pre-pack path. I think, in some ways I feel that there are already, in some ways, there is an unregulated pre-pack market already existing today. And so, people are figuring out ways of doing things. I think what we've done badly in this country is when we've tried to regulate stuff, we've regulated it badly, and it becomes just very hard to handle. We sort of we legislate for exceptions rather than sort of for principles, and so that is my fear with the sort of how the pre-pack will come out. But yeah, I think it's definitely something that is worth experimenting, and there is no reason why we shouldn't be having pre-packs for all CIRBs. The only thing is, again, that I don't know, again, I don't have the data for this. I haven't seen how it has worked for the MSME. So from what I hear, it's
not a great success.
Yeah, it's not picked up really. So.
Venkat, could we have your thoughts?
Nothing specific. I've just slightly in a contradictory view to what Dinkar said. I'm not in favor of looking at a pre-pack with the existing promoters of the company. Pre-pack in a soft way, in an unregulated way, could work out as a base bid through, and then follow it through a Swiss challenge under the IBC. Maybe an alternate or a via media start to test it out. You could have a kind of a base, bid available through discussions to save time in the process, use that, and then get through a process of Swiss challenge under the IBC to discover the right pricing. Maybe an experiment which can be tried out here. But the benefits of the IBC will obviously need to be had in terms of the acquisition of whitewashing, etc. So otherwise, the question will come in terms of the banks would again still have the same problem of the right level of price discovery, the questionability of how this has been agreed upon and how the potential bidder was kind of agreed upon. All of those questions are likely to happen. So there needs to be a process which could eliminate, and Swiss challenge is a good method to kind of, that gives a reasonable certainty of the base bidder to say that he or she has a window to acquire the asset, but subject to any improved price discovery if the creditors want to try it out, can be tried out. Maybe a via media solution is what I'm prescribing. It's not the regulated pre-pack which I'm discussing about. It's a pseudo pre-pack, I would say.
Yeah,
which can be
I agree with that, because I think the pre-pack mechanism currently is so heavily regulated and so process oriented that itself will has so many compliances that even a minor departure from that can lead to challenges.
Yeah.
So I'm conscious that we are running out of time, and I had 2-3 more questions. But sorry, Deepak, do you have any thoughts on pre-pack before I move on to the next one?
Just a very quick thought. What Venkat mentioned, I agree with Venkat, and just building on what he said, is the timing at which you allow a pre-pack for the existing promoter or the management to get the entity is important, because you could be starting that process very early, and with early warning signals, you could start that process. That would entail some amount of sanity to the process, saying that you've started the process in time, rather than so therefore those checks and balances are very important if you want to give it to large prepacks, so that would really help the process. For example, if you were starting off at a early warning itself, saying if a default has happened just prior to that, or around the time when the first default has happened, that those sort of checks and balances would need to come in.
Yeah, got it. Thank you for that, Deepak. So sorry, as I was saying, I had a couple of more questions, but since I'm running out of time, I'll restrict myself. I don't think I'll be able to go through all the questions I had. But there's one question which I think Mr. Kocher also started off with, which I'm going to address to Venkat, since you were in the hot seat in ILFS. So if you can just tell us what you think worked over there, and from your experience in ILFS, do you think there is a need for a more formal statutory recognition to a group insolvency process?
Yeah, exactly. I mean, that's been the success. What really happens in most of the Indian corporate structures, especially if you are in the infrastructure space, there's always this multi-layered, holding pattern that happens. You have a parent company, you have a subsidiary under that for a particular business. Let's say you have an infra player sitting on top. He's got a road vertical, he's got an energy vertical, he's got a third vertical of maybe, let's say, EPC construction. And each of that companies would again have the underlying SPVs sitting below that, multiple toll roads, multiple energy assets, etc. So what really the problem that we figured out in the ILFS structure was the value was sitting at the lowermost tier of the hierarchy of the organization structure, which is at the SPV level, which was actually the cash flow generating businesses, which fundamentally weren't bad. There were mismatches in the capital structure. Some were over-levered, basis the cash flows that those SPVs could generate, which was seen, which could have been tweaked around by a minor, restructuring of the debt, or tweaking around the capital structure of those SPVs could have been achieved. The problem remained at the holding companies. So at the top core, there was borrowings, high level of borrowing, which then flowed down into the next level of intermediate holding companies in the form of both equity and different colors of debt, which again was a intermediate holding company with no assets being owned by them, which they can again flowed down to the next tier in the form of equity and different forms of debt. So what we figured out we had to navigate through about 300 plus companies trying to understand the multi-layered structure. The resolution approach that we adopted was starting from the bottom up. Start monetizing at the asset level, and then the recoveries flow up. So if there is an equity value that's created out of the SPV, which is then going again into the first layer of holding company, which then again ultimately ends up being the recovery for creditors at that intermediate holdco or at the ultimate holdco. So that's how the whole resolution process was structured. You start resolving at the bottommost, the cash flows and the recoveries keep, once you resolve the debt at the SPV level, if there is a positive equity that's coming up, it moves up into the next level of holdco. And where did that money come from? It's the creditors' money of that intermediate holding company, which was further given to the SPV as an equity instrument. So we created the resolution from bottom up, and then we ensured that the concept that was created was distribution to creditors happens at all levels. Thereby, the people who have lent money at all the levels of the hierarchy in the ILFS structure get some amount of recovery, the highest being at the bottom and the lowest being at the topmost holdco. But there was some recovery which flowed in, which then, that was one of the fundamental, aspects that we worked around. And this could be achieved because we had to create, pick up lessons from IBC, pick up threads from Companies Act, provisions of various laws that were existing in place. And we had to create a custom built resolution framework, first of its kind, which was created. It took a while to create it, but now having learned the lessons, there are tweaks that are required there. It's not correct the first time. What we would really advocate is to use that as a case study, case in point, and make those tweaks, make those learnings that's coming from the ILFS saga, and then create a group insolvency framework. Because fundamentally, a lot of companies in India have a multi-layered structure. And if you had seen the history of the Lancos of the world and the others of the world, which have all gone into liquidation, because those companies which were admitted under IBC never had any asset. The only thing that was up for offering was the equity that they held in the subsidiaries. So if we take the whole group to resolve, for example, there might be interest in the buyer universe to acquire the company as a whole, as a group, because they also acquire cash flow generating assets. They also acquire a certain corporate capabilities within that. It would make sense for the buyer universe to look at these sort of companies to acquire, and therefore group insolvency we would advocate, at least personally myself, based on the 3.5 years of experience, having worked through the ILFS resolution, it's a must, especially in the Indian structure. Otherwise, discreetly you take the whole coup, it's not going to fetch any value. But it is a challenge, because fundamentally the law needs to be modified to the extent that the underlying SPVs may not have been an NPA, may not have had a default, but purely for the purpose of value recovery for the whole ecosystem of creditors to this group, we need to bring in that framework, and we need to get the alignment of all creditors at all levels. So we had that challenge going through the ILFS resolution process, but we had to work through at each layer in terms of how do we kind of communicate the message, how do we ensure that the framework is fair to the entire ecosystem, especially to the creditors at various levels in the group. So it's been a great learning, and it's been a great experience, and I think we would be happy to kind of contribute in terms of translating that into a group insolvency framework if something were to be developed, and we feel the urgent need for creating that in India. Looking at the outcomes of various of those holdcos going into liquidation for want of a better resolution option.
Thank you, Venkat. Thank you. That's very interesting. I think one of the points you mentioned is quite insightful, that the way companies are structured or businesses are structured in India is that they tend to be a hive of group companies. So even if the business is integrated for all practical purposes, for various reasons, the promoter wants to house them under different corporates, whether it is for tactical reasons or whether it is for commercial reasons or tax reasons. But that's something which is quite prevalent in India. I'm not sure how prevalent a similar structure is overseas, but yes, in the Indian ecosystem, that's something which I think all of us have witnessed quite a few times. So I'm conscious that we don't have much time left. So though I had 2 more questions to address to the panelists, I apologize. I don't think we're able to get there. But I'll leave Mr. Kocher to do a formal vote of thanks in the end. But from my side, thank you so much to all the panelists.
Thank you.
It's not very often that we get a panel of such tremendous caliber and such tremendous experience. So my sincere thanks to everyone for having made it. And thank you very much for some very insightful comments, which hopefully we'll be able to put down on paper as well. Thank you so much.
Thank you so much.
Thanks.
Thank you, Suharsh. Last but not the least, that paper we are going to put down on would be your to do. If you could kindly help with that and fast, it would really help us do the conference proceedings.
Certainly.
I would not hazard any of our folks writing it, because it's all legalese. We will write down something which is constitutionally untenable or something like that. So thank you very much. Lovely meeting you all, and look forward to building and carrying this relationship forward.
Thank you so much.
Thanks. Bye.
Thanks.
Thank you.
Thank you. Thank you. Bye-bye.
Bye-bye.